Rosa Parks will be forever known as the woman who literally sat down for justice and changed America for the better. Her act of civil disobedience in 1955 on a public bus in Alabama was a key turning point in the civil rights movement, which culminated in a ruling by the U.S. Supreme Court in which segregation on public buses became unconstitutional. By the time she died in 2005 at the age of 92, Parks had suffered for many years with a progressive case of Alzheimer's disease. As I wrote about this in my book, Alzheimer's, Widowed Stepmothers, and Estate Crimes, cognitive decline is often used by relatives to challenge the validity of wills and trust, which is exactly what happened in Parks' case. The mother of the freedom movement had a modest estate valued at a reported $372,000. However, at the time she wrote her will in her mid-80s, she also created a nonprofit organization called the Rosa and Raymond Parks Institute for Self-Development, to which she donated important and valuable civil rights documents and artifacts. The value of those items was, of course, incalculable, but certainly well worth into the millions. And so, Parks' nieces and nephews challenged her will and trust on the basis that she was mentally incompetent when she wrote the documents and was also unduly influenced by a close friend who, it turned out, received 90% of the estate's royalties, while her relatives were to receive only 10%. A resulting lawsuit in probate court was settled just before it went to trial. But new and related court battles immediately cropped up. The opposing parties moved on to argue about attorney's fees, a dispute that went all the way to the Michigan Court of Appeals. Then an attorney who represented Parks' friend and the nonprofit institute allegedly and inadvertently disclosed confidential settlement information in open court and in front of a newspaper reporter. The transgression so enraged the probate judge that he ordered the lawyer's client to forfeit all rights to Rosa Parks' royalties and properties. Of course, as happens in litigation, that ruling led to another court case, which, several years later, went to the Michigan Supreme Court. In the end, the Michigan Supreme Court ruled that no breach of confidentiality occurred and that Rosa Parks' wishes, as she laid them out in her will and trust, were to be followed. By this time, the legal battles were already 7 years in the making. The last we heard, there may still be lawsuits pending between Rosa Parks' relatives and her nonprofit institute. The lessons from this case are several. First, Rosa Parks probably waited too long before crafting her will and her trust. Second, Parks' relatives were almost certain to be unhappy that a friend would get 90% of the estate while they would get 10%. If Parks was indeed in full control of her mental capacity at that time, even in her mid-80s, she might have taken medical and legal steps to head off challenges to her will. Of course, if she had dementia, the very nature of the disease affects self-awareness, and this lack of awareness affects judgment. Of course, this is 2020 hindsight. Perhaps it's still a valuable lesson for today's older baby boomers who may now be facing similar circumstances. Before you go, please let me know if you'd like to receive a free copy of my first book, The Wolf at the Door, or my second book, Alzheimer's, Widowed Stepmothers, and Estate Crimes. Just send your address and an email to me at hackard@hackardlaw.com, and I'll be glad to put one in the mail. I'm Mike Hackard from Hackard Law. Thanks for watching.